side, it's growth, not austerity. The problem of ASEAN is in the follow-through. There's a weak follow-through. Now, I saw in the press these days that the numbers have been bandied around 90% of implementation. I'm skeptical about some of those. It depends how you measure. But I think everybody who's serious about ASEAN knows that there's a problem of follow-through, that a lot of things are adopted, and then when you look at the follow-through, sometimes at the formal level of implementation it is weak, and even when there's formal implementation, that's not only what we're concerned with. We're concerned with actual compliance and results on the ground. It's not enough just to pass a law. The law has to be implemented. The law has to be complied with. There has to be a change. And there's a problem. It's not a problem of ASEAN. It's a regional problem. It's a generic problem towards the rule of law. And that's one of the things that our integration through law project focused on. We did not go into design issues. It was a policy decision we took. Our approach in this project was, if that's what you want to do, you've defined it in your instrument, in your charters, then we will look critically and see if you've given yourself the instruments that would enable you to do it, and on the policy ground, try and make suggestions which will allow you more effectively to achieve that which you, operating in ASEAN way with consensus, have decided you want to do. That's the philosophy of the project. The volumes speak for themselves. These are good academic volumes, but some of our stakeholders are also policymakers, and there's a lot of policy recommendations. So this is on the policy dimension. So policy area number one, follow-up implementation, enforcement. And here's something that is so simple and cannot be politically controversial. There is no systematic repository where you can find all the output of ASEAN decision-making process, number one. And number two, very often it's difficult to decide, and the member states of ASEAN quibble among themselves whether this or that output was meant to create legal obligations or was just aspirational and hortatory. Our policy recommendation, following the tradition of civil law countries, have an official journal of ASEAN, so that every output at the time it is made would either have to go into the non-binding part of the official journal or the binding part of the official journal. So let the argument take place at the time the measure is appointed. It gets an official number, and you have obviously online in these days, like Hansard's, like an official repository managed by the Secretariat with the legal output of ASEAN in a manner that is easy to track, easy to follow through, and slightly easier to implement and comply with. The ASEAN Legal Service. When we think legal service, we always think, when we think law, we always think dispute settlement. And no, dispute settlement is the non-important. In public international law, we know that getting to the World Court in The Hague is epiphenomenal. It's on the periphery of international legal life. The reality of international legal life does not take place in The Hague. ASEAN needs a legal service. It needs a legal service in drafting. It needs a legal service in giving opinions on what instrument means. It needs a legal service to circulate lawyers from the member states of ASEAN so that they become acculturated and trained in the legal materials. You need a legal service to assist the politicians when they're negotiating with other countries, when they get knocked about on technical stuff like rules of origins, etc. And you need to build an expertise that will not be built in the ministries of the different member states, because even in the Attorney General chambers, ASEAN is one dossier among many. It's not as if there's somebody who spends his or her days and nights on ASEAN law. right now, in the Secretariat of the ASEAN, the legal service consists in less than 2 lawyers. It just can't be. It just can't be. It's just not serious. And the money exists. Despite the pitiful budget of the ASEAN Secretariat, because of the principle that every member state gives the same amount, they don't even spend that amount of money. So the money exists and the expertise can be built up. So the naysayers will say, where will we find the experts? You become an expert when you do it. You get good graduates from around and they will become experts. So we have a wonderful study by Walter and Jean-Claude Piris on what would be the shape of a serious legal service that ASEAN could have. And it's important for us to emphasize, this is not a political move. You know, there's a debate whether the Secretariat should be general or secretary. And we decided that right now the mood is that the Secretariat is more secretary than general. Fine, we live with that. All our proposals on the Secretariat are without changing that political decision that it's more secretary than general. It could still be a much more effective Secretariat, so that's one example. There are 2 things on, you know, they're going to announce, I should say we, I don't know. In December, we have achieved the ASEAN Economic Community. Since it's underspecified, yes. The question is what depth the ASEAN Economic Community will have. So I just want to highlight 2 of the policy recommendations. Incidentally, the policy recommendations are not of the project. We invited every set of authors on the basis of their research to come up with policy recommendation. And we have this booklet, which takes the principal ones for all the different studies, and this booklet is available also as a PDF file on the website of the CIL, on the homepage of the ASEAN project. So there's an issue of NTBs, non-tariff barriers. The history of trade shows that most NTBs that obstruct trade are there by inertia, not by design. And that if you could get rid of an awful lot of them just by talking your way through. And all the experience of free trade shows that when you look at regulation among member states, it's not discriminatory in nature. They really are concerned about health and safety. And you can have mutual recognition. You don't have to have the same regulation if different regulations achieve the same result and you just have a principle of mutual recognition. So here again is a technical, non-political decision that could be taken which would seriously upgrade the ASEAN Economic Community. Just task force NTB, non-tariff barriers. There's a political one. It's very difficult to imagine an ASEAN Economic Community which is not a customs union. Now, we all know that that's a problem because Singapore is a free trade area agreement. And if you're going to have a customs union, the common external tariff will have to be 0. So the question is to assess what is the loss in revenue that the other states will have by having a customs and a common external tariff 0, and to see if there are ways through taxation, a whole variety of instruments. I mean, after all, there are so many free trade area agreements in common to achieve custom duty 0, at least on industrialized goods, shouldn't be a task beyond ASEAN. So we had a wonderful study by John Wu and his team on the implementation in the administrations of the different member states. And as you expect, because of the different administrative procedures and because of different practices, you're not going to have the same kind of efficient administration in country A and in country D. There's no secret, that's what we expect. But the approach that our authors took, and they come up with one of these policy recommendations, is this does not mean that there cannot be improvement, and here's a role for the Secretariat: knowledge management and sharing of best practices. So at least get the officials in the 10 member states who are responsible for implementing ASEAN and for following through ASEAN to get together, to have training sessions conducted by the Secretariat, to share knowledge, best practices from other member states. It's a win-win. There's simply no downside. There's simply no downside. It's not taking place today. It's a little bit, once it's decided, it's in a black hole of the member state administrations. That's not good. There seems to be a practice. Some of these are signed by ASEAN, some of these are signed by the member states of ASEAN. Our research team were not able to find real rhyme and reason why some of these external trades were by the member states and some were by ASEAN itself. It looked as if it was a haphazard decision, not a policy-driven decision, and not driven by legal considerations. In fact, there are advantages to have an ASEAN agreement in terms of somebody in Indonesia very it introduces discipline among the ASEAN member states, but especially it introduces a practice of designing a common negotiating team. So it's good for the ASEAN sort of way. We do things together. There's better negotiating leverage because other countries cannot try and divide and rule because they are negotiating with an ASEAN team. So we have a simple proposed solution. Present ASEAN as a single actor in external trade agreements, including the framework of the dispute settlement procedure. We could not find a real reason that was presented to us why it's the 10 plus the world rather than the 1 plus the world. Because after all, for the 10 to reach an agreement with the rest of the world, they have to agree. It's not as if Indonesia is doing one thing, Malaysia another thing. They all have to agree on the same text. If they're all already agreeing on the same text, why should it not be an ASEAN text? Political actor in international organization. Again, a wonderful study that we had. And I'm just going to pick out one thing from the study. It's important that ASEAN officials, ASEAN nationals, be officials in the WTO, in the United Nations, in all international organizations, international civil service. There will be more nationals of ASEAN member states appointed as officials if ASEAN acts together and puts pressure as ASEAN. They just have more leverage. You can imagine that if it's somebody from Romania competing against somebody from Myanmar, the chances of the Myanmar official to be appointed are increased if ASEAN weighs in as ASEAN. So simple, such a trivial little policy recommendation, but actually quite important. Also in the European Union, well into the 90s, studying European Union law was not a compulsory course in all law faculties in Europe. Now it is. But it took about 40 years. But the problem of ASEAN is that there are practically no systematic courses at undergraduate and even at master's level. It's a very haphazard thing. And yet if we want to train future leaders, future bureaucrats, future officials, future administrators, future businessmen and women, to be aware of the new context that ASEAN, that we have to do something about education. And one of the things that this project is proposing, since we have covered ASEAN systematically, to use this systematic coverage as a platform to produce modules of teaching. There might be a need for translation. Somebody, I guess it will have to be in Singapore, will have to write a check for translation. And producing these modules, what we could do here at CIL, what we could do here at NUS, is to arrange summer courses to train the teachers. So train university teachers, technical universities, normal universities, different faculties, economics, law, political science,